Welcome, welcome. My name is Christina Manley. I'm the Director of Sales here for Chelsea Retirement Community. We are excited that you're able to join us here for our event. It's called Healthy, Wealthy, and Rise. And we are excited that we have a speaker by the name of Roxanne Chang, and also Linda Madden, our social worker, will be joining. And we will be going over some of our household items that we kind of have to go over, all the fun stuff about Zoom instructions. So we're going to go through that here. So understanding Zoom, probably a lot of us have seen or have been part of, a lot of these webinars. So your video will remain off and you will be muted. This webinar is recorded. And you have the option to submit questions and get them answered by pressing the Q&A button, which that'll be at the later part of our virtual event here. So I just want to add a little bit to that. So we also have the flow of the event. So the first speaker will be our elder law attorney, Roxanne Chang, who will be providing an overview of elder law related topics and concerns, including power of attorney and managing a loved one's assets and estate. And then we will be having Linda Madden. She's our social worker and on our clinical team here for assisted living. And then we're going to have Nicole Adams, which is our sales advisor. She'll be joining us as well towards the conclusion of this virtual event to answer some of those sales related questions. And now I'd like to introduce what everybody's been waiting for this evening is elder law attorney Roxanne Chang.
Good evening, everybody. Thank you for joining on this cool spring evening. Ooh, it's a bit chilly today. I hope everybody's well and healthy. I am an elder law and special needs attorney out of Plymouth, and I have worked with individuals with dementia for quite some time, and older adults. I actually started off as a limited license psychologist working with individuals with memory loss and dementia. So it is a pleasure and honor to be here this evening. I really wanted to provide an overview for you what elder law attorneys do. So if we can go to the next slide, yes. What is elder law? So, well, pretty much we meet the legal needs of older adults. And I'd like to see us as part of an interdisciplinary or holistic team of providers, including healthcare providers, but oftentimes I think elder law attorneys are not necessarily seen as part of that big picture, but I would like to think that we are. And because I think we have a lot of commonality and as far as our goals are concerned, really, which is to ensure the well-being of older adults. And we can go to the next slide. Okay, so what can we do to help? So some of the things that we do, we cover standard estate planning, getting your legal documents in order and planning for incapacity and what happens to your estate when you pass and so forth. But we also, assist with support and protection of individuals who've already are considered to be incapacitated through probate courts. We will often plan for long-term care, whether it's identifying financial sources or government benefits like Medicaid. We are often seen as Medicaid attorneys, but I like to be seen as something broader than that. Hopefully we do much more than just that, but helping families and individuals to find appropriate levels of care. We also assist in a lot of coordination of resources and supports and advocacy to ensure quality of life and care. So we really do have really a social work aspect, if you will, to what we do as well, which is what I really enjoy about assisting my clients and families. And as you may know, we also often will see some family conflicts or disagreements in, how do we best provide care and trying to balance autonomy with safety right, and independence. So oftentimes we will get involved with trying to mediate conflict, help run family meetings and the like. Right. So really, so our goals as elder law attorneys really should be that we are still working to ultimately, no matter who our clients are, because oftentimes we will either be sought to assist the individual, the older adult themselves, or family members will come to us to ask for assistance, right? And how to best care for a parent and so forth. But at the end of the day, us attorneys should always keep in mind that we really should, no matter who our client is, try to preserve the dignity and individuality of older adults, to try to maintain their independence as much as possible, to practice, promote the rights of self-determination and decision-making, and maximize quality of life and quality of care, right? So we should always keep that in mind when providing services as an elder law attorney. One area I think though, and I had a lot of questions posed already that people have, and it relates to decision making and estate planning. So I'd like to spend some time in this area to start. I think it's really important, and hopefully all of you have gotten or will complete your documents, your legal documents, with respect to planning for incapacity, as well as where you want your assets to go when you pass, right? Okay, so, but I really want to emphasize again that the concept of self-determination, because there really can be a tension or trying to balance preserving the rights of the individuals to make decisions about themselves versus having someone else step into their shoes and taking over those decisions for them. If you can imagine when you are going through your typical day, think about all the decisions that you make. Like, what are you going to wear? When are you going to brush your teeth? When are you going to eat? What kind of snacks are you going to have? Which is the one I like to exercise way too much. So, but these even seem like mundane decisions, right? We kind of take them for granted. But then if you can imagine if somebody else started to make those decisions for you, even the mundane ones, like when you're going to get out of bed, right? Whether you're going to go to work, those decisions, if someone else made them for you, I think if you start thinking about that, you realize how much these, even what seems to be mundane day-to-day decisions, really affect our feelings of self-worth, our identity, right? Autonomy. So we really need to keep in mind that self-determination truly is a fundamental human and civil right, right? And so a person has the right to make decisions and choices about their life or their future, obviously medical care and treatment and mental health care and treatment, financial management, and down to the basic daily decisions, right? But when it comes to the legal side of things, right, we tend to look at medical and financial decision making, but we have to take a step back and remember the big picture as well, that any decisions related to an individual really relates to freedom, independence, dignity, and quality of life, right? Even though I'm talking about legal stuff, right, it is important that this falls within a larger picture. And it is a fundamental human right, right? So we really need to be sure to try to protect that as much as possible and honor it. So when we're talking about though capacity and incapacity, because I'm sure oftentimes when you have somebody who may have some needs or some assistance with making decisions, we come across these terms. And you might also see these terms called competence and incompetence. But in Michigan, we really rely on the terms capacity and incapacity. And it is a concept determined by courts whether somebody has the capacity to make decisions but it's also with respect to whether or not a person has the required capacity to sign legal documents like powers of attorney, right? These are slightly different, right? And so the law imposes certain requirements depending on what kind of capacity we're talking about and how do we determine whether or not somebody has capacity or incapacity to make decisions for themselves, right? But we always want to start with the presumption of capacity, right? A person is to be considered having capacity unless otherwise determined not to, right? By a court of law or by two doctors, etc., right? Under the law. So we always want to be careful and mindful of that, because I have seen people sometimes who will say, well, they will base or make presumptions about a person's capacity based on a diagnosis. For example, if somebody has been diagnosed with dementia, right? Sometimes lay people or people who are not familiar say, well, they have dementia. Of course, they don't have the ability to make decisions for themselves, but that is simply not true, because there are different levels of capacity, and maybe that person is in the earlier stages of the journey and totally has the ability to make certain decisions. They might need a little assistance and guidance, but they still maintain that right to be able to make decisions for themselves. So we always want to start with the presumption of capacity. Okay. Now, again, in the legal realm, we are really focused on two main areas. So I'm going to touch on healthcare decision-making as well as financial decision-making. Note, I just will note ahead of time that my slides, I tend to put more information than I will completely cover in detail, because I just like to do that, so you have some additional information for future reference. I could talk about these subjects for a couple hours even, right? This evening, I'm just going to provide you a brief overview, but hopefully we'll be able to address some of your basic questions related to these documents. Okay, so for healthcare decisions, there's actually two ways to assist somebody in decision-making with respect to healthcare. Probate court, you might have heard of guardianship, right? Guardianship is a way to set up and appoint somebody through a judge to be able to make healthcare decisions for that person, right? But that circumstance is when the person has not planned ahead and did not, execute or sign some legal documents ahead of time. So I call it planning for incapacity. The alternate is planning for incapacity, and that involves papers like powers of attorney for healthcare, right? You might have heard of that. So I'm going to touch on these two subjects briefly, just so you understand what the difference is, because there's a lot of people who get confused between the two. Okay. Okay. Guardianship, just again, overview. It is a process where you petition a probate court requesting a judge to declare somebody as incapacitated and not able to make their own healthcare decisions. And the judge will then appoint a guardian to step into their shoes and make decisions for that person. So in other words, it is a public declaration of incapacity. But note, guardianship is not your first go-to in order to be able to help somebody. Really, this is only should be used if there has been no prior planning. In other words, if the person has not signed legal documents ahead of time, naming who they want to be able to help them. So guardianship is actually viewed as more restrictive than assisting somebody with decision making through a power of attorney, because you are now approaching a judge to say, this person no longer has the ability to make decisions. We're removing their rights to make decisions for themselves and giving it to somebody else, right? So it's often viewed as the involuntary way to give someone else the power to be able to make decisions for them, right? So this is not the standard that we should go to try to plan for incapacity. If we can avoid court and avoid a public declaration of incapacity, I think most of us would prefer that, right? Because there's also no guarantee who we want to help us is going to be the person appointed as the guardian. The judge gets to decide that, right? So I think in order to be able to take matters into our own hand, I think we would rather plan ahead and avoid. Who likes to go to court? Nobody likes to go to court. Even us attorneys don't like to go to court sometimes. So it's not it's not very fun. So let's see if we can avoid guardianship instead and plan ahead and get some papers in place. Okay. And you can read these slides yourself, but it really gives you an overview of what the powers of the guardian is. But you'll find that these powers are exactly the same as those in a document that you can prepare ahead of time, which is the power of attorney, right? But it relates to healthcare, where you're going to live, what services that person's going to get. But these powers are actually very similar, right? So you can go on to the next slide. And I think I talked about this too just now. We want to avoid guardianship. It should not be our first option when we're talking about trying to assist somebody with decision making, because it is a declaration of incapacity. We are removing their rights to make decisions for themselves. You're dealing with courts, judges, and there's no guarantee that the person that you want is going to be the person appointed as guardian. Okay? So you can read these slides in more detail. But what I really want to focus, if we can help it, is how do we avoid the need to go to court and get a guardian, which is patient advocate designations. In Michigan, we have to be confusing and we call them something else. Some people refer to them as powers of attorney for healthcare. Some people refer to them as advanced directives, right? But technically on the books in Michigan, we call it a patient advocate designation. You're designating a patient advocate. And this is the way to keep yourself out of court. So hopefully you all have done these papers, right? So, but it is that if a person is 18 years or older, can sign this document. And what you're doing is you're designating who you want to be able to help you with decision-making with respect to healthcare if you are unable to make your own decisions, right? So this document names who you want to assist you, but note that they do not have the power to assist you until you are declared to be incapacitated, right? But you get to name somebody ahead of time to avoid court and avoid guardianship, and you can name as many alternates as you want, right? But the idea here is that you want to name who you want that is going to honor your wishes and preferences. The patient advocate that is named must, to the best of their ability, honor your wishes and make decisions as if you would make them. So this is particularly important when you're talking about end-of-life treatment. Here's the big difference with this document versus guardianship. When a guardian is appointed, they do not automatically have the ability to make end-of-life treatment decisions for that person. You have to get a court order if you want anybody to stop or withdraw treatment when it comes to life-sustaining treatment, right? If you feel strongly, have preferences that you do not want your life to be prolonged, you make sure you do this paper, because this will ensure that your wishes with respect to end-of-life treatment are honored, right? This is where there's a big difference between the two. And I think it is even more important for people to have, right? But this document, again, names who you want, but it does not give that person the power to act until you are declared to be incapacitated. And under Michigan law, that requires 2 physicians to be able to state and certify this person is no longer able to make decisions for themselves, right? But this keeps you out of court. This is exactly under Michigan law. If someone has this document, you do not have to get guardianship, okay? Know that in Michigan, we also have the ability to name someone different as our patient advocate for mental health treatment. This is because you might have a aunt who is a really good psychiatric nurse. So you might say, I would rather have her be the decision maker when it comes to my mental health treatment. And you may have a nephew who is, you know, a physician, right? An internal medicine physician. So and you want to name that person for your healthcare decisions. So we do have the ability to name different people for mental health treatment versus medical treatment, just so you know. But oftentimes people will pick the same person, right? But I just wanted you to know. Okay. Now, you might have heard of living wills. Living wills in Michigan is one of the few states in the nation that does not honor living wills by themselves. In any other state, a living will is if you indicate your preferences regarding end-of-life treatment in a document by itself, it will be honored by healthcare professionals. In Michigan, we have to actually give our patient advocate the power to make end-of-life treatment decisions. It's a little different. So we can use living wills as a supplement to help the patient advocate understand what your wishes are, but you have to specify in the document, the patient advocate designation, that you want to give that person the power, the ability to make end-of-life treatment decisions. So we're a little different than a lot of other states. So I just wanted to clarify that as well. Okay, so that in a quick nutshell is the difference between guardianship and healthcare decisions and how you can avoid the need for probate courts and the importance of healthcare decision making. The other area that people really like to talk about is financial decision making. How do we help somebody to pay bills, manage their finances, etc., if they are no longer able to? And it's a similar setup. We have probate court for conservatorships, but again, that should not be our first go-to, right? Really, if we have other legal documents in place that are done beforehand, if we set up our estate, we may not need the court to be involved with our lives, right? And so again, we want to try to avoid court as much as we can and explore other options before resort to the use of probate court for a conservator. But conservatorship, just quickly, so you understand, conservatorship is regarding financial management, right? Guardianship is for healthcare, conservatorship is for management of finances to assist the person if they are not able to manage their financial affairs, right? Through the court. And next slide, okay. Yep, so here are the powers, you know, paying bills, distributing funds, managing assets, investing, so forth, right? So those are the powers that a conservator has. But you'll find that for durable powers of attorney, this is the document that provides the same powers that a conservator has, or it should anyway, if it's drafted well by a good attorney. So a durable power of attorney is the same idea. This is a legal document that where you sign and say, hey, I name who I want to be able to manage my finances, pay my bills, invest, right, etc., on my behalf, especially if I'm not able to act, if I'm determined to be incapacitated later. Right, so it's very similar to the healthcare one. You are designating who you want to be able to assist you in these matters. Okay. So they can be very broad. So that's when we say maybe see on the title of a document, general durable power of attorney. General means very, very broad powers, right? And so under those circumstances, and that's usually what we recommend for people, right? If you're generally planning for incapacity, you want to give broad powers to the person you name to be able to help you in various matters financially. And this is where I think it's also especially important if you are able to work with an attorney to see one. I understand that we can sometimes be kind of expensive and cost prohibitive. So, but the reason why it's really important to see an attorney versus going to get a free form somewhere when it comes to especially financial management is because even though our document can say, I give broad powers to so-and-so to be able to, do everything I could, to manage my financial affairs. Financial institutions still find that is not good enough. They want to see very specific powers spelled out in the document so that if the person you name has to go do something like open a bank account, the financial institution will look to that document to see exactly whether or not that power is listed in that document, right? So this is why it's particularly important if you are able to go see an attorney to get these papers drafted. Also, we can modify these documents to really suit your particular needs, but that is really why it's especially important because we want to make sure that it's written thoroughly and tailored to your needs, right? But that's what a durable power of attorney is. And durable, the term durable just means it lasts through incapacity, right? So in the good old days back in England, when somebody signs a power of attorney, it is no longer effective if the person that signed it becomes incapacitated. Durable means it lasts through incapacity. So that's why we really rely on it for incapacity planning, right? So again, specific, powers of attorney can be specific if you want though, but it can be like, I want to give my, son the power to sell my house. And it can be very limited. That's what we mean by specific, right? We talked about general powers of attorney and then durable, it lasts through incapacity. Okay. Before I get on to the other documents though, powers of attorneys, both the healthcare powers of attorney and the financial power of attorney. So this is where we really want to not jump to conclusions about whether or not somebody has the capacity to sign these documents. Okay, so under law, we have different levels of capacity required to sign documents depending on what the document is. For the powers of attorneys, under law, it is what we call sound mind. The person has to have sound mind to be able to execute these documents. And this is a legal capacity requirement, right? There's capacity to make healthcare decisions. There's capacity to make financial decisions. This is the capacity to sign legal documents. In this particular case, for powers of attorney, it is called sound mind, which is the lowest level of capacity required. Okay, so if somebody says, well, that person couldn't have signed the power of attorney because they needed to understand the document they were signing, everything in it. That's not true. You know how many people we like to click on that software licensing agreement, right? How often do we do that for our apps and for our phone, right? And do we read it ever? Do we read them all? I don't, honestly. I don't even read it, right? And do we really understand everything that's in it? No, we don't, right? Even us attorneys have to look stuff up. So it's not the requirement that they have to understand everything in the document. The idea is that they need to understand the effect of the document, right? What does it accomplish? If they have a basic understanding of this is who I want to help me, this is who I want to help me with healthcare decisions, talking to the doctors if I'm not able to, and this is the document that allows me to name who I want to help me with, financial matters, paying bills, filing tax returns, etc. All right. So it is in the lowest level of capacity required when we're talking about legal documents. So just because somebody has a diagnosis of dementia, memory loss, etc., intellectual disabilities, whatever it is, cognitive impairment, that we don't want to make the assumption that they do not have capacity. Send them to an attorney. It's our job to determine whether or not the person possesses capacity to sign the document. So we don't want to say, let's go straight to guardianship or conservatorship, send them to an attorney first to figure out what is the best path and what are the available options. Okay, so I hope that makes sense. All right, so moving on to other documents with respect to your estate plan. These are more related to what happens to my stuff after I'm gone, right? So For wills and probates, just so you understand that if you have a will, that is what goes through probate. Okay, so wills are to address any assets that has no place to go when the person passes. So if you have a bank account that you own in your own name, and let's say no one else is an owner on the account, and there's no beneficiary on it, and it's not owned by a trust, then nobody has the legal power to access that money in your bank account when you pass. This is why probate court gets involved. Probate court relates to giving that an executor, we call them personal representatives here in Michigan, the power to be able to reach that bank account and be able to distribute it or give it to who you want in your will, right? So that's what wills are. Wills are, and we call it a last will and testament, which is different than a living will, right? Living will is what I want when I'm alive. Last will and testament is where I want my stuff to go when I pass, right? And so probate court gets involved when it comes to assets that has nowhere legally else to go. Nobody has the power to give whatever that asset is to somebody else in accordance with their wishes. That's why probate court gets involved with wills, or right, or if people die without a will and they didn't do anything else. Okay, so it's the process by which title of property is transferred to other people. Okay, so but there's all sorts of ways to avoid probate court. So understand that as attorneys, we also try to help people to avoid court once again, because who wants to deal with that? It's not very fun. Other ways to avoid probate, joint ownership. For example, joint accounts, right? When you have two people that own an account, when the one person passes, the remaining person, the other joint owner, becomes the sole owner of that account. Now, I will caution you though, because a lot of banks love to tell people to say, oh, well, mom, why don't you put daughter on as a joint owner, just in case, mom, if you need help with paying your bills. Okay, so now daughter is on the account. Well, by doing so, every joint owner has full legal right and title to that account. In other words, daughter can then take all that money out of that account, even though it was mom's originally, and go and have a good time, right? Legally, right? And I've been involved with exploitation cases where it's very hard to get that money back. So I caution people because a lot of people don't think about that. Or let's say the daughter is really trustworthy, right? But then daughter gets into a car accident and gets sued. Guess what? They can go after that joint asset or joint account because daughter has full legal right and title to that asset. Right? So joint ownership is not the best way. I've heard people say, well, I want to add, my son or daughter on as a joint owner to my house. Same concerns, right? So there are better ways to do this. For example, with the bank account, the bank account is in mom's name. All right. But let's say mom now needs help with bill paying. We just talked about another legal document that will allow daughter to be able to assist mom in bill paying without putting her on as joint owner, right? So the power of attorney, right? That is exactly what that document is for. So you don't have to put daughter on as a joint owner, right? To avoid probate, you can, instead of putting daughter on as joint owner, you can put daughter on as beneficiary. So beneficiaries, beneficiary designations, pay on death accounts, etc. Sometimes they call them transfer on death, right? Any directive that you can give to a financial institution where you say, whatever is left in my account, or the life insurance proceeds that I have, or the retirement assets that I have, the IRA, if there is a beneficiary designation, that avoids probate. You don't need to have probate court involved because the financial institution knows who to send the money to, right? Knows your wishes, and they can do it without the need for probate court involvement. So there are various ways to avoid probate, but you see on here too, gifting, well, yeah, you could gift away your assets before you pass, but some people don't want to do that because you might need it, right? So, but yes, you can gift before you pass, but then we also have living trusts. You might have heard of living trusts as a way to avoid probate. Now, I included some information about trusts, but I will let you read that on your own. That is much more complicated, but the idea that I want to convey this evening is living trusts may be very helpful as well as part of your estate planning documents, but it is not always required to avoid probate, because I just told you that there are other ways to avoid probate through beneficiary designations. So be a little wary if you see attorneys that say you have to have a living trust to avoid probate. That's not true, right? There's other ways to avoid probate. So just understand trusts have its place. They have some other benefits, so I would recommend them usually during other situations, right? Like if you want further control after you're gone, right? So like if you have a child who has a gambling problem and you want to slowly give them their inheritance, you don't want to give it all at once because they're just going to, gamble it away, right? And so there are very specific reasons why trusts may be very helpful, but no, you don't need one just for the sole purpose of avoiding probate. But definitely you want to consult with an attorney about that, right? So, but that is definitely a way to avoid probate. Okay, next slide. Okay. All right, so moving on, I know I'm throwing a lot of information at you, but I just wanted to give you an overview. And I know people had some particular questions with respect to estate planning and planning for incapacity. So that's why I spent a little more time on that subject. But I'm not gonna, now this whole subject area, I can talk for hours on this subject. All right, so I'm not going to be able to do that this evening, but I just wanted to give you a quick overview. You can read these slides yourself with respect to what we can do to help pay for long-term care. And it really depends on where the care is being provided. Is it at home? Is it at assisted living or memory care, or is it at a nursing facility, et cetera, right? So there are various sources of care, payments for care, depending on the level of care we're talking about. But people are often most familiar when it comes to us elder law attorneys, when it assisting people with eligibility for Medicaid, right? Medicaid is where we look to have the government help us to pay for nursing facility level of care. And that's often where we will have clients that will seek our assistance in that matter. So if you want to move on to the next slide. But I want to also keep in mind that, yes, we do a lot of protective planning, asset protection for nursing facility level of care. Yes, it's really expensive, but you know what? You saved your money for a reason. It is to ensure that you have quality of care over time, right? And so just understand that a lot of people think the end all be all is to get on Medicaid. And that is simply not something that we should have as our primary goal when it comes to long-term care. Yes, I totally understand that people want to leave a legacy, want to leave assets for their children, etc. But at the end of the day, you know what? Number one, Medicaid is not for inheritance protection. Number two, really, when you have resources to pay for care, you, at the end of the day, may very well have better access to quality of care and quality of life, right? You have more options when you privately pay or find other sources besides relying on government benefit programs to pay for care. That's the bottom line. So it kind of disturbs me a little bit when I see elder law attorneys say their sole focus is to get people on Medicaid and protect their assets. No, the nursing facility is not taking your money. You are actually paying for care, and that is to be quality care, right? You have more options, and generally that care is better care. So just keep that in mind. You hear it time and time again about attorneys, elder law attorneys, Medicaid eligibility, protecting assets, but at what expense? it could be at the expense of quality of life and care. Okay, so we can move through these slides as well. I gave you some information about the differences. It's very confusing between Medicare and Medicaid. I know that people get confused, but Medicare is the one that you get when you're age 65 or older, or you are considered disabled and getting Social Security disability, right? So I gave you some slides about what the benefits are when it comes to Medicare. With respect to older adults, that often comes into play when somebody needs rehab or short-term care in a nursing facility, for example, right? But it's not for long-term care, right? So Medicare is really looked for short-term services in a rehab facility, right? But not long-term. If they need custodial care and assistance with bathing, dressing, etc., let's say somebody has dementia, that's where private pay or sometimes Medicaid, this is where it does come in handy. I think of it, try to remember it by aid, Medicaid. Aid is the program where if somebody cannot afford to pay for care at a nursing facility, long-term care, then the government will aid them, right? So that's how I remember the difference between the two, right? But here are some slides that you can also review when it comes to Medicaid eligibility and what the differences are with Medicare. And we can quickly go through those, but I just want you to be aware. Again, I could talk about these subjects for a very long time, but at least you'll be able to take this home and take a look and understand the differences and how we determine eligibility for Medicaid as well, right? For a single person under $2,000, the person can't have more than $2,000 in countable assets. That's not very much, right? But for married couples, understand that if one individual is in the nursing facility, another one is in the community, in other words, not in a nursing facility, rest assured there are some additional protections. And there's a math formula on how they determine whether a married couple is and where one spouse needs nursing facility care, how they determine asset eligibility. And it's a lot more than $2,000. So that can be comforting to a lot of people, right? If it is really needed. Okay, so let's get through these slides. You can keep going. Okay, so other legal issues then that us elder law attorneys will assist people in, maybe it's coordination of benefits and advocacy and quality of care and recipient rights issues, right, as required under law. People who reside in nursing facilities and assisted living facilities, etc., do have certain rights that they maintain in these while they're living in these facilities. Other issues are related to abuse, neglect, and exploitation, which could be a topic for another day, and things like driving and how do we address issues related to whether someone is able or unable to safely drive. So I know I threw a lot of information at you very quickly, but I hope that at least it gave you an overview of what we do and the issues that we can assist people with, and at least some basic information for you that's helpful.
Thank you, Roxanne. Very informative, and we will have a time for question and answers here in a little bit, but I wanted to introduce you to Linda Madden.
Hi, everybody. My name is Linda, as Christina mentioned, and since 2008, I have been serving the residents and families of our assisted livings here on the Chelsea Retirement Community Campus. So that's Glacier Assisted Living and Towsley Village, our memory care assisted living. So it was really my pleasure to be here with Roxanne this evening. I learned a lot. I'd just like to take a few minutes to tell you why it's so important from my perspective to follow her advice. And she really had great advice. So first of all, she urged you to be proactive, and I wholeheartedly agree. In my career here at Chelsea Retirement Community, I have unfortunately seen way too many people acting in a crisis situation rather than coming to assisted living prepared. So with some effort now, the transition to assisted living will be much easier for everyone, for if you are moving to assisted living, or for your loved one, and for the family. So especially if you have a relative who is living with dementia, you need to start thinking and acting long before you have determined that the time is right for a move. And even if your relative's cognition is intact, you and your loved one should consider that, according to many experts, over 40% of people over the age of 85 will develop dementia. So I would advise, if you have not already done so, consult an elder law attorney like Roxanne to complete both the patient advocate or medical and the financial powers of attorney. This, as she said, is vastly superior to the necessity of a court-appointed guardian or conservator who may not know anything about your loved one or his wishes, and she mentioned that. I would advise scheduling a medical appointment, and many facilities, ours included, whether you're going to our traditional assisted living or a memory care assisted living, we require that an applicant submit a medical report from her physician and also have a doctor's order for admission, as well as up-to-date prescriptions. And then Roxanne mentioned this: if your relative is living with dementia and can no longer participate in decision-making, then you need to think about requesting the letters of incapacity from 2 physicians, and those letters are necessary to activate your patient advocate status. Because Towsley Village, our dementia care assisted living, is a secure facility, and that means that residents do not, in the memory care assisted living, don't have the ability to leave the assisted living on their own. We require that people admitting to this facility have their patient advocate status activated, and so we need these letters. Don't put off this step, because I've seen some really sad occasions where a person living with dementia is in a crisis situation and must, for her own safety, come to live in a supportive dementia care facility, but the patient advocate designation has not been activated, and we can't accept that individual for admission. So please also, as Roxanne said, have a discussion way before a crisis situation with your loved one about his advance directives and what his choices are in the event of an illness or end of life situation. And I also encourage you to begin a personal and social history and a care routine for your loved one. You can keep these documents on your computer and update them as needed, because that will help us to know what those choices that Roxanne was talking about, whether your loved one likes to get up early in the morning or sleep in, do they prefer tea or coffee, are they a gardener or a farmer? Those things really are crucial information for to help us start off on the right foot when you move to a facility. So, and those documents can be helpful not only when you move to assisted living, but they can be invaluable for you if you, the care partner, become ill or hospitalized and need to have someone step in and care for your loved one in a crisis situation. So I would advise that. And I wanted just one more thing before we go to question and answers, but I wanted to touch on was that Roxanne mentioned that you can have alternates or successors as patient advocates. And I think that's an important thing to do, because if we've had some situations in my career with people who have named only one person as a patient advocate, and that person has predeceased them or has themselves become incapacitated. So if you think about having a second or even 2 alternates, I think that's really a great idea. So that's what I have to say. Christina, I'll turn it back over to you. So.
Thank you, Linda. Thank you both, actually, Linda and Roxanne, very informative. It helps us too, as a sales team with myself, and I know with Nicole here, she's on for the assisted living sales team. But we do face these daily when we do have an admission. It's so important to have these documents in place so that we're able to process this information, this paperwork, and be able to provide the best care that we possibly can for your loved ones. So yes, please, I urge you to fill those out and get those taken care of before a crisis moment. So again, this is time for question and answers. So we do have at the bottom of your screen, it shows a Q&A. If you can go ahead and type in a question, and then we will go ahead and direct it to the panel here. So we do have Roxanne, Linda, and Nicole from the sales team. And to start us off though, while we're waiting for some questions to come in, we did have a couple questions prior, and a couple of them were touched on from both Roxanne and Linda. But one of the questions that came in, is there issues getting a power of attorney for a parent with dementia?
And I would say it just depends, right? Again, if the person is in the earlier stages of the journey, then there still very well may be an ability to have them sign the documents. And we, at least I anyway, try really hard to find capacity to try to keep people out of court. So again, as Linda said, the earlier the better. Please go ahead and try to get your affairs documents in order for that reason.
We just had a question come in. How often do you update a PAD?
Yep, a patient advocate designation is good as long as you want it to be. So it doesn't expire or anything like that. Every once in a while, it might be good to have an attorney look at it just to see if there's been any law changes or anything like that that might improve the document. But otherwise, it will be as long as it's good and in place as long as you want it to be, unless you revoke it, and you always have the right to revoke the document or tear it up and say, I don't want it in place anymore.
Let's see here. What about a trust? I heard 6 months.
Okay, and so again, trusts also will remain intact for as long as you want it to be. Now, there are some reasons why you may want to seek an attorney to review your documents and update them if need be, if there's been some law changes, or maybe changes in your own personal circumstances where you might want to update them. But there's no hard and fast rule. I mean, they will be in place as long as you want them to be until you revoke them or change them. But generally, we advise that periodically it is good to review your documents to make sure they say what you want them to say, still are relevant to your specific situation, and there haven't been any law changes as of late. So always good to review that. Okay.
We have another question that came in. I'm the executor of my parents' will. I'm not sure what the responsibility entails at the time of their death. Please educate. And I would also like to write my power of attorney and health directive to reflect change in marital status. Is this something I could do?
Okay, so as far as the responsibility of an executor, and that really is the personal representative in someone's will, and this is the person that would have the legal power to administer the estate, or other words, assets that belong to the individual that no one else has that legal power to reach. So that's why we need to go through probate and get a personal representative appointed. Before that person passes, there's nothing you need to do. Once that person passes, though, if there are any assets in that person's estate, in other words, there aren't any beneficiary designations, no joint owners, it's not in a trust, then you may need to contact an attorney, I recommend that anyway, to open a probate estate at that time. Just because you're named in a will does not mean you automatically have that legal authority to be able to deal with that estate. That's why probate court is involved. Probate court needs to give you the special paperwork that you need at that time in order to be able to do things on behalf of the estate. With respect to updating powers of attorney or patient advocate designations, I think the question was if you had a spouse that, I'm sorry, Christina, did you say that they were deceased or they passed away, or it was a change in circumstance?
At the time of their deaths.
So understand powers of attorney are only good as long as the person is alive. Those powers as an agent or a power of attorney or patient advocate end as soon as the person passes away, right? So a lot of people get confused about that too. But as far as updating documents, it usually, again, is really good to update documents if there has been a change in circumstance with either yourself or the people that you name. So it's good to maybe seek assistance from an attorney to do that.
Okay, it looks like we have a couple more questions that just came in. What does a person do if their parent advocate can no longer carry out their duties? Person has no family willing to assume the responsibility.
Okay, yeah, if there are no alternates named in the patient advocate designation, or if there are alternates named, but there's no one else that at that time are able to act as patient advocate, that is really when guardianship may be necessary. For the reason that guardianship, a court can appoint what they call a public guardian, which is often an agency that will serve as guardian, or sometimes they will appoint what they call a public administrator, which is often an attorney that will then serve as guardian. So one of the few instances where guardianship may be necessary is if the person has no one else to name in their patient advocate designation that is willing to help them and assist. If there's no family members available, no close friends, that's when we may need to resort to guardianship, because otherwise it's voluntary, right? To serve as patient advocate and make decisions for somebody else, it is totally voluntary, right? So.
And someone wanted to comment also, another thing to consider in joint ownership is tax liability of surviving owner.
And yes, and really, luckily in Michigan, we have no inheritance taxes. In Michigan, there's no death tax, there's no inheritance tax. And right now, what we do have is the estate tax on the federal level, but at the time, I don't think it'll affect the majority of us because it's over, you have to have more than, it's around $11 million plus before the estate tax is applicable. And for a married couple, it's double that. So unless we're super independently wealthy, we don't have to worry about taxation in that regard, right? So I'm not sure exactly if that's what this person was thinking about, but I hope I addressed that issue, right? So, okay.
And we have just a couple minutes here. We do have a question about how to obtain the PowerPoint, and they also gave kudos, an excellent job, well done. Thank you very much to you both. The power presentation, I will be talking about that in just a moment, but we will be able to provide that within the next couple of days, a link to this PowerPoint, and it will also be given to by Allie, and I'll go over that a little bit in just a moment. But I do have one last question here. How can you, oh, here it is. Is there a wait list, a deposit required? How long is the wait list? Do you accept long-term care insurance? I think that might be for Nicole.
So we currently don't have we have a wait list, but we do have rooms that are available right now. If you wanted to get on the wait list, if you're looking for maybe in the future, or maybe you're not ready to move within the next couple months, We do take $1,000 deposit that is 100% refundable. If you don't come here, you let me know, I send it back to you. If you do come here, then it gets applied to your first bill. I don't remember the other part of the question.
And then I was just saying that, do you accept long-term care?
We do accept long-term care insurance, yes.
All right, well, we are actually at 7 o'clock, but I did want to mention just a couple items before I say good evening. I would like to thank you all for joining us this evening. We had a really good topic here. I know it's been something that's been requested, and so I am very happy that we were able to provide a look at, and kind of discussing those elder law questions, and then how that relates with our community, with Linda. But we do have, you can see this slide here. It's just thanking you for joining us. We have our sales contact, which you can contact our sales assistant, Allie Watson. She'll be able to get you in contact with one of the sales advisors here, which Nicole is a sales advisor for our assisted living. So there's that. And then there's also, it was asked about sharing this presentation. So Allie will be in contact with you within the next couple days. You will be getting an email that will have a link to be able to view this, which is very helpful. I know even for us, if you weren't able to join, or if we have families that are interested in these topics, we definitely also send that out to them as well. It's a great resource, and we love sharing this information. So again, thank you for joining us, and I hope you have a great rest of your evening.